Thank you, Paul. I have some housekeeping things to do. I think I'm going to wait till we go on break, which is after this presentation, and I'll cover those things with you at that time. And I want to just take a moment here, introduce Umberto Bonavita from Robert Allen Law, both the firm and individually good friends of ours. But he's partner at Robert Allen Law, advises clients in general corporate and international business transactions. Incidentally, you have these bio notes in the little pamphlet in front of you, and I'm only giving you highlights. So look those things over because we have some pretty impressive folks here, and their attributes are all listed there. So Umberto is going to in turn introduce his panelists, and the subject is, and I hope, is conflict management and dispute resolution. And this is not a discussion of domestic relationships, is this, by chance?
Potentially.
Okay, so the principles are probably the same. Umberto Bonavita.
Thank you. Thank you for the introduction. Welcome, good morning. So we have a fantastic panel. Jason Dunbar, Luke Brown, Joe Stanley, fantastic attorney, litigator, and Rob Newton.
Who's also fantastic.
Yeah,
I'm sorry?
Also fantastic.
Yeah.
that's right.
And Rob.
And Rob.
Well, I had to make a plug for the attorney.
Thanks.
Well, by a show of hands, how many in the audience have personally been involved in a dispute, be it an arbitration or a lawsuit? That's less than I would have imagined. But how about from a transactional perspective, maybe if you or your company were not necessarily named parties to the dispute, perhaps a client of yours, by a show of hands, have you been on transactions that went south or for whatever reason? Okay. Yeah, so this is something that's dear to our hearts. From the attorney's perspective, dispute resolutions are viewed in a certain way, but I'm always also always interested and fascinated by a non-lawyer's approach and thoughts on dispute resolution, especially on the commercial or the business side. So I guess, Jason, I'll start with you from a yacht broker's perspective. When you think of the term dispute resolution, or you see the provision in contracts that you might be working on, what comes to mind?
Well, what first comes to mind is that the nature of what we do is to prevent that. Like when you add a yacht broker, the idea is to remove hindrances to commerce. And the hindrances tend to come from, at least in my experience, it seems on the back end, broker to broker. As Rob mentioned, there could be over there just a minute ago, somebody was excluded in when they lost the listing and they had exclusions, and then somebody off that exclusion list buys the boat. Stuff like that seems to be what dominated my career, were the things that were behind the scenes that you never wanted the buyers or the sellers to see. And then when there was disputes between buyers and sellers in that where something was misconstrued or a breach of a contract, that's kind of where we put our hands up, try to resolve that peacefully with predictions of outcomes. But if we couldn't do that, we'd call on somebody like yourself.
Rob, another broker's perspective, your thoughts?
Well, I think that my personal opinion, the key takeaway is just not get involved in lawsuits, no matter how right you are. Generally speaking, in our industry, the other person has a lot of money and is willing to spend it, and they'll drag it on for years. And even if you win, generally you don't get your court costs back, you don't get everything. And most important to all of us, our asset is our time. And if you're spending time and emotional energy dealing with a lawsuit for a couple of years, it takes away your ability to do your job, and it does wear you down. So I think that if you're bound and determined to go down that route, arbitration is probably the best thing to do first, and you can get a taste for what's going to happen in a court.
Yeah, I think that's an insightful approach. We as attorneys, we always hear, and there's some truth to it, that the only people that end up winning in a lawsuit are the lawyers, not the plaintiff, not the defendant. it's, even if you win, you come out with scars and money that you spent. So it's kind of a Pyrrhic victory, even if you prevail. But Joe, your thoughts?
Yeah, absolutely. And I'd even go a step before what Rob was saying, that arbitration is great, mediation is better, and that's the dispute resolution nerd in me. But if you can get to, and mediation is provided for in the IYAC rules, it's a sort of a precursor, if you will, in many cases, where you can have control over the dispute when you're in mediation. The parties have control. Arbitration is great because you get a verified ruling at the end of it, a verdict, if you will, a term that people understand. We call it an award that's enforceable. But if you can mediate beforehand, I do think that it's important for this industry. It's such a small community, even though we're international, in terms of preserving relationships. Sort of what you mentioned as well, our topic here includes conflict management. And when you're mediating, everyone has a say, and the parties control the outcome, as opposed to me, an arbitrator, telling you at the end, you were right, you were wrong, and so forth. But definitely, if you can avoid litigation, as a former litigator of 20 plus years, I tell you, avoid it. It's a long, drawn-out process, and particularly right now, the dockets are clogged. If any of you have been in litigation, you know it takes maybe a year, sometimes two, to even get to trial. And if you win, you're probably out $250,000 anyway, plus your valuable time. We call it ADR, is the lingo, alternative dispute resolution, which encompasses mediation, arbitration, negotiation, facilitation. Anything but litigation is definitely the preferred route in terms of, like I said, primarily relationship management and preservation, because you guys all have to work together again, and to maintain that, I don't want to use the word veneer or facade, but the image of professionalism. It's helpful if you all play nice, as we say, and get along and have these conversations together, and control the outcome.
Yeah, I think to your point, how you want to avoid litigation, one thing about litigation in courts is that it's public. So the docket is public. You can do a Google search. It'll show up on Wikipedia. People can go and see kind of the dirty laundry that's being exchanged in a nasty dispute, especially with high net worth individuals, yacht owners that privilege their and value their privacy. Litigation.
Well, we had the Tiger Woods case, right, where he has a yacht called Privacy, and sues because, and I think it was Christensen, I forget which builder, had displayed photographs of it while it was being built, and he sued for the violation of privacy. It was a term in the contract they weren't supposed to disclose, like an NDA. And it was just that irony that because he took it to litigation, everything about privacy became known.
Public.
Yeah.
Yeah. So that one advantage of arbitration is the privacy, the confidentiality.
Sure.
Please.
I as somebody, I do expert witness work, and I get to witness the trial version of a conflict resolution. And I've also experienced arbitration. And one of the aha moments that I had in arbitration, which you don't learn at birth, and it became very apparent the true value of it was, in arbitration, there is a lawyer that's going to be on, that will keep the discussion within the boundaries of the law. And basically the law, correct me if I'm wrong, but that's the minimum society will accept. That's like the bare basics
Correct.
of what you have to do.
Essentially.
Within the arbitration committee, there is somebody like Rob or Jeff Stanley or Andrew Silla that would be on that committee that understands the traditions, norms, and customs of our industry. That is a key ingredient that is massively different than a courtroom setting when you have a judge, a jury, two lawyers that are debating the parliamentary procedures of maybe a transaction that was disputed. Where in an arbitration, you get somebody that is sitting on that board that can say to the lawyers, hey guys, I understand what you're saying, but this is what we traditionally do, and this guy did not follow that, or this girl did not, she did. And and it sways the opinion of the arbitration. And I think that that is just a key ingredient that speeds it up, probably reduces the cost.
Oh, for sure. It's a key component historically of maritime admiralty arbitration. In fact, for the longest time, lawyers weren't allowed to be maritime arbitrators. It was always men of the industry. And by men, I use that universally. But it was understood that folks who worked in the industry would arbitrate these types of
Yeah,
cases.
who
because
broke the boundaries of the
understanding.
traditions and norms
Yeah,
of,
customs and practices.
right.
Yeah, it's certainly a risk to have a dispute resolution in front of, let's call it, lay people, a judge or jurors that may not be in the yacht industry, don't know much about the yacht industry, and it's kind of a niche area. It's in a lot of ways it can be its closed universe, and if you work in it and that's your profession, sometimes you take for granted that your knowledge base does not translate to lay people. And so, like, for example, we had a dispute that ended up in court where the plaintiff filed a lawsuit because the dealer had changed one of the engines that failed, the starboard engine, and replaced it with the same model engine directly from the manufacturer because it failed before the sale. And so the plaintiff found out, they didn't tell him that they changed the engine. From the dealer side, parts and components fail all the time. So it needed to be replaced, and we replaced it with the same exact spec, same exact engine. It went before the judge in a hearing, and the judge was like, I can't believe this. If I buy a Mercedes-Benz and the dealer changes the engine and doesn't tell me, I would be horrified. So that's kind of to give you the perspective, I think, a lay person versus perhaps maybe, and I'd be curious to get your opinions if you think that that's something that should be disclosed or it's a matter of course. They got the same engine, they got the same manufacturer. What's the big deal? That's just to give you an idea that if you're not resolving your dispute in front of industry insiders that know the industry, know how it works, it can increase the unknown and the risk factor.
In that particular case too, which I was involved in with you, the guy, the plaintiff was, because the motors were not, the nomenclatures of the motors were not sequential, 4151, and then it wasn't 4152, that he had lost a tremendous amount of value in his boat. That'd be just because those motors were not in sequential line. And you needed somebody that would understand the customs of what is the loss of value on that,
Right.
So that's one of the, the topic up here is conflict resolution, and essentially it's communication also. So when you're talking about letting people know anything that might be of importance or even little things, the broker's communicating, and preferably in writing on this, and letting them know and discussing it with the buyer and the seller ahead of time, you avoid this because, in fact, as a broker, I tell my people if one engine's new, it's a benefit to you. It's not a negative, it's a benefit. You might have to rebuild the other one someday to get it equal, but at the point of time that just because they change something is not wrong. And if you educate the person in the beginning on that and let them know, you'll never get to this dispute stage.
For sure. I mean, and as an arbitrator, one of our mantras, of course, is if you think it needs to be disclosed, disclose. Transparency, again, conflict resolution, conflict management, conflict prevention. Transparency is the key. And disclosure is preferred. If you think it's going to become a problem, avoid that by stating it up front. And I also advocate that you don't speculate as to what you might think would be a problem. For example, on the back of a boat, having a conversation with another broker about maybe the boat sank previously, I'm not sure. Some of you might remember that case. But, don't speculate. Be honest. Of course you are. You're ethical individuals in a highly regulated profession. And if you think it needs to be disclosed, disclose it and, prevent the problem.
Are there any, just curious, any prevailing or repeating dispute themes that you're encountering in transactions?
I think the ones that there are potentially non-disclosure of a reduced commission when it comes time for the, after contracts have already been pushed back and forth. Oh, this is a, 5% deal, 7% deal. Sometimes that can get a little bitchy, but it doesn't seem to get to the lawsuit end. In my mind's eye, I think the kind of the biggest, I don't want to call it gorilla in the room, but or elephant in the room, it is the material. What is material damage? That language in contracts always scares me because it's so subjective. And I think if there's any one potential for, somebody getting litigious, it would be that language. You didn't disclose that. And I got to be honest, I really think forums like this, where it's on the record, where we are debating stuff like this to discuss it, sets a precedent. So the opinion of the room, the wisdom of the crowd, I think will have a long-term effect on, is it breach of hull, fire, and sinking? Does, as Paul mentioned earlier, a lightning strike from 15 years ago, whatever, does that really have any material value to the, how would you know? And I think these things need to be discussed because there could be difference of opinions in the room.
And maybe all the better reason to have the dispute heard by yacht professionals.
And procuring cause, I don't know, that's another one that could become a very problematic, and especially with boat shows. Just take somebody and walk them boat to boat to boat to boat. You never see the person again, and just start making a claim on every, because I walked them on the boat. These are things we need to think about and discuss. I mean, it's an evolving business. Things change.
Rob, your thoughts?
So procuring cause has obviously been something I've testified as an expert witness a couple times on that. And in both the cases, it was decided by a jury, which frankly didn't really have any idea of our industry and what the standards are, but that you had to the person who physically took the person to the boat was the one who was due the commission. So, that's one. The other thing that we, briefly talked about was that how does that work also? Let's say that you had a listing on a boat and the sellers decided to move it to somebody else. And then you give them an exclusion list of the clients that you have. And a lot of times that will include another broker's clients. So is that the same thing? Does that mean that those people had to have physically been on the boat, or they were someone that the broker spoke to, or prior to the listing being gone? I mean, that can cause quite a bit of conflict. I've seen that happen quite a bit, and it's something that needs to be worked out in advance, and you need to have it in the contract, so it's all very, very clear.
Joe, your thoughts?
No, I mean, Rob's right on it. You say it up front. My husband will tell you, I don't like things to fester. So if there's any kind of rumbling of a conflict or a potential conflict, you've got to be a strategic thinker, right? You're salesmen, you're professionals and everything. You've got to think ahead and be your own devil's advocate and go, do I think broker A is going to bitch about this particular thing? Get it said and done with, because the last thing you want is for it to come bite you in the butt later on. Technical legalese bite you in the butt. It's very, very.
And when you're resolving it, correct me if I'm wrong, counselors, but do it in writing.
Yeah, absolutely. Document.
Emails, texts, it's a great way to communicate and think things through and spell it out.
Yeah.
Agreed.
And in the case where you're talking to a broker on the phone and you're going over this stuff, afterwards, just send them a quick text. Hey, we discussed this, and my understanding is this is our agreement. Just leave it like that. You have something then, because down the road it's a he said, she said, if you end up in arbitration or in court, and that never works very well. It's whoever the jury thinks they like the best.
Yeah.
Paper the file, as
Absolutely.
they say.
Absolutely.
Especially on procuring cause. It makes a difference if a broker shows, walks a yacht, shows a yacht to a client that's maybe in inventory of a dealer, for example. Send the dealer an email. Hey, thank you for organizing the showing. It was great. Please make sure that you register the client under my name. Something as simple as that. Oftentimes, it slips through the crack, it's not done, they don't follow up, and then it can be a problem when somebody alleges that they weren't the procuring cause. Well, paper the file.
Yeah, for sure. I know we've worked in my other capacity at Stanley Yachts, the boat shows with Luke Brown, and they have a great, and I think most of the brokerages do it probably, the little lead sheet, when they come to look
Boarding
at boats,
passes,
yeah,
yeah.
boarding pass, and they put their name and their information, their email or whatever in there, and then the broker follows up, and that starts that paper trail.
Yeah, you staple the broker's card to
Yeah.
it. Yeah, my concern, or I think that the conflict, and again, I'd love to hear, from the room, but if I meet you at the boat show, I just start walking you, I leave my boat, and I start walking you boat to boat. I'm on the brand new Vikings, the brand new Princesses, the Asma, and I register you with everyone. And then I'm just not qualified or good, or I say something off color, and you as the customer make a choice not to work with me. I don't know that I own that client. I think the client to some degree should have the freedom of choice as to who he works with. If I have done something that turned him away from wanting to work with me, and he meets Rob and says, this guy's sharp as a tack, and I like his
I get that.
Yeah, that's interesting because there is case law that holds that if you initiated or procured the interest in the vessel, but then you are alienated, marginalized, they kind of cut you out, not deliberately, but just because, like for the reasons you're saying, they just don't have confidence for whatever reason, or there's just not good chemistry. It happens. But an argument could be made that the client was the obstacle, the hindrance, so there should be a commission because they didn't give the broker a chance to earn that
Complicated.
commission.
Yeah.
So it's a gray area. It's complicated. How about on the transaction side? So we're procuring causes leading up to a transaction. What are you seeing in the execution of the transactions, perhaps at closing? Have you come across common themes of disputes that maybe can be avoided if approached differently?
Probably the largest is removing items from a boat. Even when I had an exclusion list on one deal, they came in and artwork and things that were supposed to stay, they cleaned them all out. And the client was not litigious, so he just said, I'm very disappointed that this happened, but I'm moving on. It's just not worth it to go down that road for me and my time. But it does end up with conflicts at closing. People say, I'm not closing. You took stuff off the boat that shouldn't be there. Therefore, you're not delivering the boat as per our agreement. So, those are things where communication is important. I had one client that the captain called me and said, you need to come down to the boat the day before closing. And I said, why? Well, the wife is here taking her personal items. And it's including more than that. So I went down to the boat, and she had a U-Haul. She was taking the furniture out of the salon and things, and I had to talk to her nicely and convince her that it's probably not a good idea. And what are you going to do with this? You're just going to put it in storage. It's going to cost you money. And we settled that out to an agreement with both parties, so it didn't end up in a problem. But generally it's communication between both sides in any deal. Really, the brokers need to communicate clearly, and you need to communicate with your client. And if you're representing both sides, it's actually easier because you can both tell them what's going on. But I think if you pay attention to the little details, that'll do. But those are to get to the closing. The biggest problem I've had is when people are stripping the boat, taking things that were not really on the list for them to take.
The dreaded exclusion list.
Yeah, but I think our contracts, and particularly the IYBA contract, is really good at addressing what is to be sold with the boat. And traditionally, prior to this agreement being modified over the years, I think we all assumed that what was found at the survey, what the surveyors would itemize on the boat, we would traditionally throw our hands up and say, hey, if it was listed on the survey, it's going with the boat unless specifically excluded. But we've gotten beyond that in our contracts with, fuel would be taken off of a boat if things got into a bit of a dispute, but that now is being addressed in the contracts. The appurtenances, I think is how you say, kind of covers a lot of ground there. It's not so much the removal when we get to the contract point. I think sometimes now the complication of the tenders and the toys and the HIN numbers, those seem to be coming up more and more frequently because the boats are collecting more stuff that need to be transferred. And that can be the things that create the hindrances most. And just recently, we've found an old lien on a boat. I think I sent that to you where.
Oh, the Coast Guard lien.
Yeah, the Coast Guard lien. And that is the person who put the lien, he's okay, but he can't remove it. I mean, it's turned into a complicated situation.
And they closed despite the lien.
Despite the lien. Yeah, and they're holding a little in escrow, but even the person that filed the lien, like, so many years ago on the boat, it's just kind of passed down. And now finally somebody said, I want that gone, even though the original filer of the lien was like, no, I'm happy. I'm content with how I've been, but he can't get it removed. And that seems to be a problem.
It'll expire eventually if they don't try to arrest the vessel. But I mean, it's an encumbrance. You don't want that on your title.
Correct.
But,
I just had a situation like that, but Coast Guard told me that it expires any lien expires in 3 years. But the attorneys on the buyer side said, well, that doesn't actually mean it's gone. They can refile it if they want. So we went and got a release from the person, but it's kind of a little bit of a gray area on that. And then going back to the listing agreement and it surprises me that very, very few people, when they're signing a contract on a boat, a buyer does not attach the listing, because there's various forms of listings out there. And so somebody could argue that, well, I'm going off this listing, and the seller's saying, well, I'm going off this one. So obviously a little more paperwork, but most everything's done, by email these days.
that's an
So
excellent
Yeah.
point.
you should have the listing actually attached to the contract. And then everyone agrees that that's effectively what we're agreeing is part of the boat.
Yeah, that would avoid the he said, she said kind of dispute that we were talking about. And to your point, Rob, I think communication is key, being proactively involved throughout the transaction, not just at the signing of the contract and then showing up at closing. Because when you're proactively involved, working with the attorneys, working with the broker on the other side, that there's communication, and proactiveness facilitates communication, and communication facilitates, my experience, a smooth closing, a smooth process.
Sure. You mentioned HIN numbers.
Yeah.
Phone numbers.
Yeah, so one of the things that I've seen more than once, and I think the point of this conversation shouldn't be these outliers or this one time. It should be the things that have the high probability of occurring most often to the cast of characters in the room and in the profession, would be a boat that's Haul ID number has a year stamped on the back of it. But then when we start to dig in and we get to the closing, we find out it's on the HIN number or on the Haul ID number, it says 20. So you think you're buying a 2020, and then you see that the manufacturer year the boat was launched in 19, and now somebody says, hold on for a second, I thought I bought a 2020. This says it's a 19, and I'm very happy that there is a long-standing precedence that the United States sees a boat that's, I think, built after August of any year, and vehicles are the same way, that you can build that boat and launch it the year prior to the actual manufacture, the stamp year on the Haul ID number. It's to keep industry moving. Manufacturers be able to produce boats and sell boats that were built at the back end of the fiscal year or the calendar year. But sometimes customers don't see it that way, and they'll maybe seek counsel from somebody like Joe or you and say, what do I do? And hopefully, I think you guys would sit there and go, sir, this boat was launched in November of 19, but it is a 2020. and you were sold a 2020 and that's what you're getting. I don't know if that's a matter of debate in the room, but I think that that's the precedence. Am I
It
correct?
can go back to adding the listing, because if you look at a listing, there's two ways that it's classified, as either year 2020 or model 2020. And if that's on the listing as model 2020, then, well, the buyer might not know it, but in fact, the broker should know it, that means it was a 19 built 2020 model.
I think well, I know this for a fact because we've actually dealt with this. The U.S. Coast Guard regulations allow buyers to request and manufacturers to change if the vessel is still under construction and it's still in the shipyard and it's delivered after June 1st. So if it's delivered after June 1st of a given year, you can put the subsequent model year. And a lot of builders don't know that. And I think yacht owners can be shortchanged because they're buying a yacht that they can get the next year model year, and they're not. And they might, it could be delivered the first week of June, and instead of getting a 24, they're getting a 23. And that's again, communication,
Yeah.
working together.
So Intrepid builds a boat and it's going to come out. They're ready to put it on the floor, and it's July 1st, 23. That can have a 24 stamp on the back of it.
Yep.
Okay.
If it didn't leave the yard from June, they have the option, and then after August, you have to. So it's June, July, which is kind of discretionary.
Okay. That's good to know. I'm learning something here. This is good.
I'll send you the reg.
Okay, fantastic.
And the bill.
Yeah.
I think Paul said he would pay the bill, don't worry about it.
Paul's covering all bills today.
So,
I welcome the audience input. We wanted to make this interactive. If there's anyone that wants to share an experience or has any questions about their experience with dispute resolution, how as an industry we can improve it, I welcome your thoughts. If anybody has any questions. Bob.
This question for Robin or Jason also. It's more about the art of.
I know you're a little microphone shy, but.
Thanks. Yeah, this is for Jason and Rob. More about like the idea of the art of conflict resolution. I've been on the phone with Jason before and Rob on many occasions about like what's going on here. We need to figure this out. And sometimes I've been on the receiving end of we've been in the wrong and vice versa. Can you talk about like the humility and humanity of it to like prevent it going to legal? And just like the way that I'm thinking about it is more like even if you're totally right, sometimes the art of compromise to make sure that we don't get in the way of a closing is really important. And the next time that maybe I call you Rob and it's the foot's on the other shoe, or as they would also say, the shoe's on the other foot, how that would benefit like a long-term relationship in this industry.
I think if you really want to break it down, it's in your self-interest to get the conflict resolved, no matter how, if you have to give a little bit in order to get it done, because it's all really about your client. If a deal falls apart or something comes up or a problem because of you specifically, not willing to compromise or anything, usually your clients don't like that and you're going to lose them. And what we want is retention of clients. So if you can work it out, it's not all about just doing this one deal. It's okay, this guy's going to sell his boat again in 3 years. I'm going to be nice. I'll get that listing, hopefully, sell him another boat. He can tell his friends, hey, this guy really worked hard for me and did a good job. That's much more important than the short term of one single commission.
Yeah, so this is a fantastic question for our industry because we have so many individuals that approach a deal with their own unique style. And when you have a house, not unlike Denison, Atlantic Yacht and Ship, Marine Max, Fraser, Energy, you've got a lot of people that do business, and maybe one person did something in a deal that now to this, let's just take a commission, for example. You submit the offer, it's accepted, then you get the call where we talked about, hey, this is a 7%, 6% deal, and that sets off a little bit of fire. You resolve it, everyone gets on the phone, you say, okay, it is what it is, we're just going to move forward, close the deal. 3 months later, the company, a totally different brokers, but you got a lot of different brokers in it. Now they're trying to do a deal again, those two houses. Oh, hey, by the way, we're only paying you guys what you guys, offered us on the last one. Even though those two had nothing to do with it. These become problematic. It becomes a gotcha. You just did this to us, now we're gonna do that to you. And I honestly feel that when these get to the dicey scenes because you've got somebody who's like, hey, that wasn't me. No, that was your office did that, and you're a representative of that office. And these become things where you want to go, okay, what are the customs and norms of our industry? What should we do? And I think really the precedence that's, having somebody that has seen this a long time and can resolve this or say, yes, we were in the wrong on that last one, or we want to treat you like we'd want to be treated, has always been just a great precedence to set, to resolve it. And, I think that being having a good business sense and minding yourself or taking care of yourself, conducting yourself like you'd want to be treated by the other person or treating them that way is really the foundation for that. And usually you can solve that stuff.
I think it comes down to, go ahead.
No, go ahead.
I think that for the industry, and I said at the outset, it's such a niche industry, it's a small community, and you have these long-standing relationships that it comes up over and over again where you're going to be working together on additional deals and everything. And it comes down to, in my field, dispute resolution field, we talk about emotional intelligence. I'm sure how many of you have heard about EQ, right? It's one of the sort of buzz things going around. And we talk about your self-awareness, your self-management of your emotions, because sometimes emotions and ego and competitiveness and all these things come into play. But also your social awareness of the people you're working with, other brokers you're interacting with, and your relationship management. And that's what is really important for this field, for this industry, is to manage those relationships by being, first and foremost, client-centered. So if you're, as Rob said, if you're focused on the best outcome for your client and maintaining that relationship, but also focused on the fact that you want to maintain and preserve relationships in your community, the people you're going to come to these conferences with and see across the way at boat shows and at open houses and whatnot, and have a little bit more of a strategic foresight towards how you're handling each other and dealing with each other, being transparent, being proactive, all the things we've talked about, sort of prevents the conflicts, but also helps you wade through them when they inevitably crop up.
I have a question.
Sure.
So as our technologies have evolved since the early 90s, our customs have evolved, and we don't necessarily consider, mailing a buck listing. And if you sent them the letter, that was kind of like I introduced them to that boat because I mailed them the listing. Then it went to the internet where I emailed them the listing. Now I owe them. And then we go to physically get them on the boat. And now I am noticing that I am doing video walkthroughs now with clients with my phone, and I'm showing the boats. I'm going through the boat with my phone, and they're wherever they are on the earth. And now are we going to start to interpret that as procuring cause? I did the video walkthrough with this. Did I physically get them on the boat?
I think
don't know.
there's strong arguments that it should be procuring cause. If we can conduct business meetings via Zoom or Teams, well, why can't you show a yacht? If the client says, hey, I can't travel, but I really want to see it, can we do a Zoom or a Teams and you take me through it or send me the video? It's not as ideal as physically being on board as a client and seeing it, but I think you can make an excellent argument that that's procuring cause.
And that's potentially one where a jury would give you a very different verdict than an arbiter. So that may be something as the business evolves that's coming down the pipe.
Yeah.
I would say that if you just walked through a boat videotaping and sent it to somebody, to me that's not really much different than sending them a lot of photographs or something like that, or a video that their broker made. But I think that when you're doing the video conference, when you actually have them on the phone and you're walking through describing it and they're asking you questions, in my opinion, is that that's procuring cause, that's the same as showing the boat. Because since COVID, everything's changed a little bit. There's a difference now in how people do things.
And I think the difference can be to kind of what you're saying, where the difference between a cold call versus a solicited video presentation of a boat.
Well, I think it's important to consider how small the industry has become, and especially on the sales and broker side. So now clients are, they have no qualms about considering to buy a boat that's in Hong Kong or in Turkey, and they're in California. And so maybe it's not realistic they can hop on a plane and go to Turkey, Istanbul to see the yacht. But if the broker can do a video walkthrough, then they, at least they might pass the first test and say, yeah, I'm interested now. Let's present an offer. So I think from that perspective, we have to evolve the same way that technology is evolving.
Right.
Yeah.
Jason, I think if I was doing that video walkthrough, somewhere in the conversation, I'd use the words, as my client, what do you feel about this? Right?
Yeah, that's a great point.
Nailed
Sure.
it.
And the
Everybody's a
follow-up.
lawyer.
And then do a follow-up.
Do a follow-up email per our little video walkthrough today. What are your thoughts? Did you like it?
Yeah, and technology is just going to keep moving forward, and we'll have to adapt to.
And as
what
Mr.
the new
Flannery
terms.
will tell us, the IYBA listing agreements and purchase sales agreements are all living documents that evolve with the times. So we'll stay up.
I'm DJ with IYC, and I think the distinction there, this is a virtual showing. It's live, as opposed to just sending somebody a video tour.
Right.
Sure. Yeah, you're interacting with the other person on the other side of the screen, and that would be. We're coming to a consensus here at a
Hey,
seminar.
done.
I like
Okay,
this.
I'm dropping the gavel. We're sorted it out.
It's now considered a tradition.
I ruled it as a precedent.
We got one more over here.
Hey, Mike Mullinger with Pier 1. So I'm about to make everybody's heads explode because there's procurative cause, but then there's also, as Jason brought up, client choice. So we've all had those situations where we've shown boats and then client realizes, hey, cousin Joe is a broker, or my friend's a broker, or I have a broker, but I saw it online and went and looked at it myself. So at what weight does client choice come into probable cause when we are in a services, customer satisfaction, protection business?
To me, it depends on how much money you want to spend on that position. Most time, conflict resolution, you can work something out, because I don't think you can force a client to work with you. However, you do have, if they do the whole tour and go through everything and afterwards say, oh yeah, by the way, I have a broker, you can call the broker up and go, let's work something out. And most brokerage firms will do that. That's my opinion. But I have had people that boat shows especially, where they'll come through and spend an hour with them going through a boat, and they said, well, we really like it, but we use so-and-so as a broker, and they're going to come, they'll follow up with you. So, okay, well.
And with very few exception, over 30 years of interacting with a lot of the different brokerage firms, and Rob, I don't know if this has been your experience, there are a few yacht brokers that don't play well with others. They want every piece of every pie, and they just don't cooperate well. But the ones that do that seem to be the least, have the least longevity in the business. They come and they go. But the ones that I've, the guys that I've seen since the 90s that are still doing it and scratching out a living, they are the most cooperative and understanding. And it is, I think they've understood that time is the commodity. And if okay, so I took this guy around, I showed him a boat, and then I get a call from another broker. Hey, the guy doesn't want to work with you. You look like his wife's ex-husband. He just doesn't want to work with you. All right, I'm out. So, tell him good luck. Whatever it is, I just don't have the time to fight that. I go on to the next one, and you're cooperative. And then it's just a matter of time before something like that happens, and the other broker reciprocates in the future and keeps everything peaceful.
Yeah, for dispute resolution, and this is also to touch upon Bob Dennison's point, I think there's something to be said if there's a dispute festering, don't rely on email all the time. I mean, yes, we were speaking about how it's important to paper the file, but in emails, I find people misunderstand each other. They misinterpret the words. There's something to be said about, yeah, you'll send the email, pick up the phone, maybe schedule a coffee, a lunch meeting, go get a drink. And in fostering those conversations, open, frank discussions, you can resolve disputes. And I'm recommending this even against our better interests as the attorneys, but because we do like disputes sometimes. As they say, blessed be the troublemakers. But I don't know, Joe, if you have any thoughts on that.
Well, my thoughts are, I love resolving disputes, bring them my way. You're welcome to come sit with your client and help mediate or arbitrate their position, but the conflict is fine, right? It helps create new solutions to things. Tension sometimes improves growth in relationships and redefines boundaries and everything, so don't be afraid of the conflict. But I do encourage the prevention piece, the management piece, and transparency and disclosure and humility, to use Bob Dennison's word as well. And just realizing that, again, if you want to stay in the industry for any length of time, play nice, and you won't be within that 90-day window of steal all the money and run. Is that what you said with regard to the regulations? But definitely resolve your disputes.
Well, I think we've run out of time.
Yeah.
So I want to thank the panelists, Rob, Joe, Jason. Thank you. And the audience, thank you.
That was great, Umberto. One thing that, it's not just the technical stuff. This is what I like about this conversation. It's not just the technical stuff, but it's good old-fashioned common sense, advice, good old savvy wisdom that they were passing along to us as well, especially with the anecdotes. That gets us right back down to the basics of dealing with somebody on a one-on-one humanly basis, okay? I want to thank, incidentally, Paul. I want to get to you about streaming, okay?
So, all of you are on social media.
No, it's not working, Paul.
All of you are on social media. I'm on social media all the time, obviously, with a voice like this. But we are streaming live today on Facebook. So jump on your Instagram, jump on your Facebook, jump on whatever it is that you're talking to your audience with, and let them know that they can participate in today's event by going to Facebook page for IYVA. So go into Facebook, hit search, go for International Yacht Brokers Association, and this event right now is streaming. And if everybody turns around and faces lead and waves, then the whole world will know that we're streaming live. So get your folks on board. There's a great chat box in there that people are asking questions as well. Fortunately, Lee has watched 47 different episodes, it's actually 91 different episodes of Yacht Engineering. He's able to answer all those questions.
Thanks, Paul. Listen, speaking of which, Wi-Fi, if you've been trying to figure out the Wi-Fi trick, I somehow looked into it. There is a workaround. You can see our staff out at the reception desk and hand them your phone and they'll get you onto the Wi-Fi here if you haven't been able to figure it out yourself. And incidentally, Paul, a special shout out to Bruce Seiler of Ocean Alexander for allowing us to borrow the furniture from the main salon of one of the new Ocean Alexanders here for our stage. And the soft goods, okay? Thank you, Bruce. Okay, those of you that have been sitting with your legs tightly crossed will be pleased to know that you're going to go on break right now, okay? So be back and we'll call you back, but let's make it 15 or 20 minutes. We're right on schedule. And go have a cup of coffee and do some networking.